Hey, everyone. Today's YouTube video is something I've been really looking forward to. It's all about rights to information, and it's meant for our IST 307 tutorial. We're going to learn about information rights, so stick around. Just click that like button and subscribe for more awesome videos. Let's begin. Introduction Chapter 1. The Right to Information Act in the Maldives grants the public access to information from state institutes, promoting transparency and accountability in government affairs. Act No. 1/2014 aims to ensure accuracy, responsible information management, and the dissemination of information. While it acknowledges limitations in specific cases, the Act emphasizes reasonable principles for upholding these rights. Chapter 2. The Act imposes significant obligations on state institutes, requiring them to disclose requested information and provide it upon request. It mandates disclosure at reasonable opportunities unless otherwise specified. The Act also establishes fundamental principles for determining disclosure or non-disclosure of state institute information, ensuring decisions are rooted in established principles. The State Institute follows prescribed procedures under the Act procedures, which are enforceable by a judicial authority, granting access to the information. The responsibility for information produced by a state institute is assigned to the office within the institute. The office with the most relevant information is responsible for a state institute's functions assigned to multiple other institutes. The state institute's functions determine the authority in whose custody the information is. Chapter 3. Individuals seeking information from the state institute must submit a written request with necessary details, address for document delivery, and payment assurance. They must also provide their name, address, and contact number. Special provisions assist those unable to draft a request due to limitations. The information officer can help with signing, witness signature, and obtaining a fingerprint. State institutes may offer request forms, but they should be efficient. Information must be provided within 21 days, extendable by 14 days for research or large quantities. Inadequate requests may be declined after notification and opportunity for correction. Persistent non-compliance can lead to rejection. Requests may be transferred to another office with consent, communicated in writing, and completed within 7 days. Chapter 4. The State Institute's information officer determines if information can be provided promptly or later, determining permissible disclosure and charging a fee if release is delayed beyond 21 days. The State Institute is required to reply in writing with reasons for refusal, the availability of requested information, reasons for delayed disclosure, and the right to appeal if dissatisfied. The law allows specific exemptions to be overridden if specific information is publicly available and written reasons must be provided for refusal. The law allows for specific future disclosure of information, which can be temporarily withheld if required by law. Applicants must be informed, have the right to complain, and the review committee's decision can be appealed. The applicant requested an inspection of the study, which included a valid transcript to ensure the information was accurate and up to date. Access was granted in the requested form unless otherwise specified. Chapter 5. Requirement of annotations. If an individual's application for amending their information held by a state institute is rejected, they can request an annotation to be added to the information. This annotation can either specify certain details that the applicant deems incorrect, untrue, or misleading from their perspective, or in cases where the information is incorrect, they can provide details that, according to them, would render the information accurate or complete. Chapter 6. This section ensures that fees for accessing information are reasonable based on the actual cost and do not create barriers for financially disadvantaged individuals. It also establishes a framework for regulating and communicating these fees. Chapter 7. The Act prioritizes public access to information, even with exemptions. Denials shouldn't hinder accountability or public confidence. If parts are exempt, non-exempt portions must be released. Exemptions cover data related to legal offenses, breach of confidence, economic management, privacy, judicial privileges, and sensitive cases. Personal info needs consent, except for public interest cases approved by the review committee. Legal privilege allows withholding investigation or trial-related information. Business data can be withheld if release causes irreversible harm. Info from foreign entities risking diplomatic relations is exempt. Private entity agreements involving confidential matters are also exempt. Health, life, and safety risks can lead to information withholding. Ongoing investigations, law enforcement, justice, taxation, and immigration matters are exempt. Information harming national security or economic interests may be withheld. Cabinet documents can be withheld, except for certain details. Provisions don't apply to info over 10 years old. Objections for third-party info are considered, and the third party can appeal if disclosure proceeds against their objections. Chapter 8, Utilization of the Right to Information Act in the Maldives emphasizes accessibility and transparency. The Information Commissioner creates a user-friendly guide, while State Institute officials appoint information officers for information disclosure. These officers assist individuals and implement information management policies. State institutes proactively publish information about their functions and services. The Commissioner establishes standards and offers guidance on information dissemination. State institutes must manage information for easy access and correction of inaccuracies. Norms for secure information management, including preservation, archiving, disposal, and disclosure, are set by the Commissioner in consultation with state offices. Section 40 mandates training for State Institute employees. Section 41 establishes a review process for dissatisfied individuals, and Section 42 requires state institutes to submit annual reports detailing their information disclosure activities, including statistics on applications, denials, appeals, fees, and more. Chapter 9. The Post and Responsibilities of the Information Commissioner. The Information Commissioner's Office, ICO, is an independent entity appointed by the President, with qualifications including age 35 plus no convictions and a degree plus 7 years of experience. They serve a 5-year term, extendable with Majlis approval, and vacancies must be filled within 60 days. Dismissal for misconduct requires Majlis approval, while resignation necessitates notice to the President. The ICO's salary matches the Human Rights Commission President's. Responsibilities encompass management, financial oversight, proposing improvements, and reporting breaches. They appear before Majlis and submit reports for accountability and transparency. Chapter 10. Implementation of matters by the Information Commissioner. The Information Commissioner oversees appeals and complaints. Parties can appeal review committee decisions within 90 days, with potential for late appeals under valid justification. Applicants can directly appeal in cases of access issues. The Commissioner may refuse appeals lacking basis or proper procedure. Proceedings must conclude in 30 days, extendable by 15 days if needed. Third parties have a right to be heard, and proceedings are generally public. The Commissioner can summon, investigate, and issue orders. Decisions may involve release of information, fines, or corrective measures. They can initiate investigations if an institute isn't compliant. Certain decision-making powers cannot be delegated. Parties can appeal to the High Court within 10 days. Failure to comply within 45 days may lead to legal action. The Commissioner and staff are immune for actions in good faith. They can also impose fines for specified violations. Chapter 11. This Act applies its provisions to associations and organizations funded by the state or external sources, treating them akin to state institutes. The Information Commissioner is tasked with formulating and enforcing regulations for Act implementation, collaborating with affected parties. The Commissioner also holds discretionary power in setting guidelines for various aspects of information management. These regulations must be enacted within 3 months. The Act places a significant emphasis on prioritizing the right to information. It becomes enforceable 6 months after its official publication. Thank you for watching.